Thank you. Very fascinating presentation. Tough act to follow, but I'll do my best. I've been fascinated by the witnesses for some time, and recently I got asked to write a chapter about their legal machinations for a volume that's coming out this year from Brill called The Global Contemporary Christianity. So this is taken from that chapter. If you're interested, you can get that volume, which probably costs an arm and a leg too when it comes out. I think a lot of you know something about the witnesses. They began in the 70s in the United States. They now claim about 8 million members. They claim a lot more than that, closer to 20 million attending their activities and conclaves around the world. I think they're actually the most litigious of all religious organizations. That could be debated, and maybe some from Scientology would defend their right to claim that honor. But I think the witnesses have developed quite a record, and I'll be interested in whether anybody disagrees with that. They have, in fact, over the years developed what Pauline Cote and I have called a vigilant litigation approach that has morphed into a disciplined litigation approach to defending their practices and their beliefs around the world. And they've been very successful in establishing precedents in a number of countries and regions that are supportive of religious freedom. Before I jump to the Europe situation, I want to remind you about the situation in North America. In the United States, hundreds of cases were filed by the witnesses in the 1930s and 40s, mainly over their proselytizing practices, about which I'm sure you're aware. They ended up winning about 50 of those cases before the United States Supreme Court, and they expanded the Bill of Rights provisions to non-federal, that means state and local governmental entities. As they did so, they helped establish freedom of religion, freedom of association, freedom of expression, and they've also helped establish conscientious objection as a right, medical treatment rights, and rights of parents to raise children within a religion, these custody cases that arise. But in Canada, something similar happened about 10 years later after the war. It's worth noting that the witnesses were actually banned in Canada for about 3 years during the war because they refused to support the war and refused to allow their members to participate in military service. A number of them were arrested and sent to work camps because of that kind of sentiment and publicity. A lot of their children were discriminated against, literally beaten, kicked out of schools. Some of them were removed from families and put in foster homes and things of that nature during that time period. They had a special problem in Quebec because in Quebec there was a very close relationship between the Catholic Church and the government. Duplessis was premier from 36 to 39 and then from 44 to 59, a very long reign for him. They won a number of cases in the Canadian Supreme Court. It's worth noting that some of them were 5-4 decisions, something we're very used to now in America. But they did win these cases, and in fact, the most interesting case, perhaps worldwide, is when they actually sued the premier and won a case against the premier who had to pay damages in 1959. I can go into more detail about that case if it interests you. And their efforts in Canada also contributed to the movement toward the Canadian Charter of Rights and Freedoms that now exists in Canada. It's arguable that without all the efforts of the witnesses in Canada, the charter might not have occurred or might not have occurred as quickly as it did. But now let's look at some European background. Post-World War II, we saw a heavy emphasis on human and civil rights because of what had happened in the Holocaust and that sort of thing in the war. And this helped lay the groundwork for witness use of the courts in Europe to promote their interests, their beliefs, and their behaviors. It's worth noting that at least 1,600 witnesses were involved in court cases during the time of the Nazis in Germany. but they were trying to defend themselves. They didn't do a very good job of it, and several thousand of them ended up in camps, and estimates are that about 1,200 of them died in the camps. So it wasn't a fertile ground for taking action and promoting their beliefs and behaviors during that time period, but post-war, the situation changed dramatically. Also, a number of those countries established constitutional courts of one type or another, and those have played a role, as we'll see later, not only in Western Europe, but it turns out that none of the countries from the former Soviet Union could really join the Council of Europe without establishing a constitutional court, which is a bit ironic, but nonetheless the case. Anyway, the Council of Europe was established after the war, and we saw flowing out of that the establishment of the European Convention for Human Rights and Fundamental Freedoms. It was approved in 1950 and implemented in 1953 after being ratified by a required number of the original members of the Council of Europe. It included Article 9 on freedom of thought, conscience, and religion, and the European Court of Human Rights was established to enforce that convention, but it didn't do that for 40 years. 40 years went by before the court found any violation of Article 9. There's this odd phrase called margin of appreciation, which basically means that the original members were allowed to do anything they wanted in terms of regulating religion. That lasted for 40 years. Here is Article 9. I think many of you are familiar with it, but note that the first statement, Part 1 of Article 9, is a very strong statement, but then Part 2, you could drive a Mack truck through it if you were so disposed, and suffice it to say that the European Court of Human Rights, the European Commission, and then the Court of Human Rights was quite disposed to allow a great deal of flexibility and used, they didn't even admit cases, much less rule on them, but the justifications were in Part 2 of Article 9. But then something happened in 1993. I'm sure most of you are aware of the Kokkinakis case. Kokkinakis was a Greek Jehovah's Witness. He had been arrested 60 times. 4,500 witnesses had been arrested for violating the Greece statute criminalizing proselytizing. They're the only religious group that ever experienced any criminal prosecution for proselytizing. But in 1993, lo and behold, the court decided to get serious about Article 9, and even though it was a split vote, 6-3, they did find a violation of Article 9 for the first time ever. I think, and I think a few people agree with me, that the timing was not accidental. The Soviet Union had collapsed. A lot of those countries were trying to join the Council of Europe. Their culture and their ideas about freedom of religion were vastly different from what the situation was in Western Europe. And so I personally think that the court was deciding it had to do something if it was going to enforce anything like freedom of religion in those former Soviet and Soviet-dominated countries that were trying to join Western Europe and participate in that kind of culture. I think it started sending a message. Since that time, there's been a flood of successful Article 9 cases, literally dozens of them, virtually all of them from former Soviet or Soviet-dominated countries and from Greece. The fact that Greece criminalizes proselytizing makes them a poster child in a sense and an easy way to start sending messages if you want to send them, even though they are defined as one of the original members of the Council of Europe. There's a chapter in Hammer and Rothstein's book that's out on display that I've done with a graduate student that lists these cases, and then I've got a chapter coming out in another volume later this year where it's even an updated list, and you can see all of the countries from whence these cases come and whatnot. From 1964 to 2013, the witnesses have actually filed a total of 209 cases, and that's through August of 2013. I'm sure the information's dated now. And witness plaintiffs have won 29 cases, make that 30, because Willie Fatra just sent out a notice that Turkey lost a case on conscientious objection alternatives to military service this past week. So they've now won 30 cases before the court, and they've had 26 what are called friendly settlements. A friendly settlement is when the government gives up and decides not to fight the case and agrees to whatever they're arguing about, whatever the case was filed about. They've lost 2 cases outright, 5 have withdrawn, 79 are still pending, and I know those numbers don't add up to 209. What happens is that some of those cases simply disappear. For instance, it's hard to believe, but in Armenia, they actually ended up filing 75 cases before the court having to do with conscientious objection. There is now alternative military service in Armenia, thanks to the witnesses, and so those cases just kind of disappear from the docket. This is a truly amazing record, I think, and it rivals what has happened in America and in Canada that the witnesses have accomplished. So this, just to comment a little bit more and give you more detail, these cases in friendly settlements have included cases dealing with registration, taxation, efforts to tax them out of business, censorship of their materials, freedom of expression, child custody, attempts to deport them, confidentiality of medical records, neutrality of the state in matters dealing with religion, conscientious objection, and the disruption of meetings, and that goes on in a lot of the former Soviet countries. They've been winning cases on those too. And even France, an original member and the home of the European Court of Human Rights, has lost a recent Article 9 case involving the witnesses because the French authorities were literally trying to drive them out of the country using a change in the tax laws they were very selectively applying the tax laws and ended up trying to apply gift tax regulations, which are very onerous, 60% tax on gifts in France, to the witnesses. And they did that to the Amish group and an evangelical Christian group, and France lost 3 cases in 2011, and that's a first, really. Then I want to talk just a minute about constitutional courts. The German Constitutional Court found in favor of the witnesses in 2005, forcing acceptance of them as a public religion, a very important designation in Germany. It took 15 years, by the way, to win that case, but the Constitutional Court in Germany is perhaps the most powerful, influential constitutional court in the world, and they have found in favor of the witnesses, and the witnesses now have that designation there, except in a couple of the lands that are still fighting losing battle. The Constitutional Court in Russia has found in favor of the witnesses in a re-registration case that eventually went to the European Court and won a unanimous and very strongly worded judgment. It's worth noting that the Constitutional Court in Russia has found in favor of some other religious groups, minority religious groups, like the Jesuits, and they also won in the European Court of Human Rights. The European Court of Human Rights does its best to work with constitutional courts when they're willing to stand up and take a position on these matters, and we've certainly seen that happening in Russia, although the Russian political bureaucracy doesn't bother to, they pay the fines and then don't change any laws or anything. The implications, Jehovah's Witnesses are now registered and active in all the Council of Europe countries, but especially in Russia, they're engaged, the Russians have decided to apply laws about extremist literature to all the witness literature, and that case is going to the European Court of Human Rights, by the way, and it'll be interesting to see what happens there. The witnesses can usually pursue their beliefs and practices more openly than before. That doesn't mean without controversy. That's never going to happen. But I would offer that other minority religious groups have also gained from many of these legal battles that have been fought by the witnesses. Article 9 is being enforced, but in a focused manner. Originally, I thought it was a double standard, and they were just being tough on those former Soviet-dominated countries and ignoring the original members, but I think that Some scholars, Carolyn Evans from Australia, for instance, in Melbourne, has pointed out, as has a former justice of the court in another writing, Garlicki, that basically what the court seems to be doing is setting up a jurisprudential pattern that protects the existence of religious groups. That was the big issue in the former Soviet and Soviet-dominated countries, is whether groups could even exist, not just the witnesses, but a lot of others. But there's much less focus in the European court decisions on individual religious freedom cases. And there's a very long list in the publications I mentioned about France winning all kinds of cases about headgear and, facial coverings and things of that nature. The court doesn't even bother with that kind of thing. But they do seem intent on allowing groups to exist, and that's where France got in trouble when they tried to put the witnesses and a couple of other groups out of business with the tax laws. Final comments. Courts in the U.S. and Canada have used witness cases to establish some important precedents. I think it's really interesting, by the way, to think about this. It wasn't that the witnesses forced the courts to take their cases. It's that the court was willing to take the cases because they were trying to expand their authority over state and local governments, and the witness cases were very handy for that. They had the attorneys, they had the mechanism, they had the will. In Canada, the Supreme Court used witness cases to establish basic rights and freedoms and to demonstrate that even the premier was subject to the law. And then in the European Court and in constitutional courts working together with the court in some countries, witness cases are being used to expand the authority of the European Court of Human Rights and establish individual rights as well as judicial autonomy in this region, this former Soviet and Soviet-dominated region that's now affixed to the original members, Western European countries. So there's been a really interesting interplay between the court and the witnesses in all three of these situations I've described. And I would just close with a couple of theoretical comments. How do you explain this? What's going on? I've coined a phrase, the theory of mutually beneficial interaction between the courts and the witnesses. It's obvious that there's been a willingness on the part of the courts to take these cases. In the United States of America, hundreds, if not thousands of cases get taken to the United States Supreme Court, and they take about 50 or 60 or maybe 70. They don't have to take these cases, and they only take the ones they want to take to send a message. So, there's an interaction going on between the witnesses and the court in America and the court in Canada, and I would offer in the court in Europe, the Council of Europe. My other thought that I would leave with you, there's a notion of third-party partisanship in the theories of Donald Black and the sociology of law. He basically says when somebody who's not supposed to win a case because they don't have the resources or the statute or the status or they don't know people in high places, when they win the case, you've got to explain it. And he basically offers this theory that somebody's got to be standing up for them that does have a little juice. He calls it third-party partisanship, and he did it with a former student of his named Baumgartner. It's in his book, The Sociology of Right and Wrong, is the chapter on third-party partisanship. And it's obvious that in some of these cases, the witnesses have occasionally gotten some help, but not too often, not too often. And so in some of my writings, I've raised the question of whether the courts themselves can be considered third-party partisans, and that they're willing to be considered third-party partisans on behalf of the witnesses and on behalf of religious freedom because they have their own agenda. Think about it. Thank you very much.